NGRI. Dr. Rinsberg returned his report, finding that he also believed, similar to the doctor at North Coast, that the defendant was legally insane at the time of the commission of this offense. So this matter has been set at the request of the parties for a non-jury trial, and I believe, and I'll let the parties put this on there, but there's a stipulation as to the facts in the case, as well as to the, which include stipulating to the findings of both doctors. So let's go forward from there. I'll start with Ms. Missouri. If you want to put forth on the record what the facts are, the stipulation. I guess you don't have to read the whole thing. I do have a copy of it, and I've read it beforehand, but let's put forth for the record how we're proceeding here.
Thank you, Your Honor. Yes, there is a 4-page statement of fact that has been signed by the defendant, Ms. Tuttle, and I as well. This sets forth all of the facts of this case. It starts with an incident that had occurred earlier on in the morning on February 25th, and then it outlines the incident that occurred at Speedway in Wickliffe, and then at Walmart in Eastlake. So all of that is set forth in this 4-part document that the parties are asking the court to include in the record. And additionally, there are multiple exhibits that are mentioned in the stipulation of facts, and they're all joint exhibits. The first one being the CAD report for that 5:14 in the morning incident on February 25th. Then there are multiple exhibits that relate to the Wickliffe Speedway incident. Joint Exhibit 2, which is 911 calls. Joint Exhibit 3, which is the closed caption television video for Speedway. Then there is Joint Exhibit 4, Wickliffe body cam recordings. And Joint Exhibits 5A through 5G, which are photographs from that incident. Then moving on to the last incident that happened at the Eastlake Walmart, we have Joint Exhibits 6A and B, which are photographs. Joint Exhibit 7, which is Walmart store surveillance video. Joint Exhibits 8A through 8D, as well as 9, which again, more photographs. And then finally, we have Joint Exhibit 10, which is the sanity evaluation dated August 11th of this year, and Joint Exhibit 11, which is the second sanity evaluation dated October 2nd of this year. Both parties are asking that all of these exhibits be admitted.
Thank you. In terms of the charges themselves, is the state going forward on all the counts? I asked, there's 2 robbery charges, obviously.
Sure, we would ask that those would merge, Your Honor, if they're for the same incident.
We just dismiss the F3 one, can't we? I'll be honest with you, I don't know how merger works with the NGRI.
Sure. No, I think it would probably just make the record clearer if we did that. So we could.
Count is that?
Count 2?
Is the F3.
Yes.
So then the state will dismiss count 2 at this time and proceed just with count 1, and then 3, 4, and 5, correct?
Yes.
You're fine with that?
I'm perfectly fine with that.
I'm assuming you have no objection to that?
No objection, Your Honor.
So when you do the entry, you'll put So does that sound accurate, what Ms. Missouri just laid out for the court in terms of the stipulations that were entered into between the parties?
That is accurate, Your Honor. Mr. Lehman and I have both signed the stipulation of fact. We would ask the court to accept the joint exhibits, and we would acknowledge that the stipulation of fact and exhibits do cover the entire indictment.
I was reading the set of facts, so it would be paragraph 3. It said when he got in her vehicle, but then he couldn't get it started, he exited the vehicle, striking her and causing her to fall to the ground. How did he strike her? With the
With the
door
door.
or with,
It was with the door, Your Honor.
so it wasn't that he struck her with his fist or some
No.
weapon or anything like that? It wasn't necessarily even, he's not charged with assault there. So it wasn't intentionally striking.
Correct, it was the
Yeah,
force
the
of the
door.
door, yes.
Mr. Lehman, you, well, you know, technically this is a trial, right? I'm assuming both sides, neither party, does any party want to give an opening statement and all? Waive that?
All I would say, Your Honor, is I believe that the statement of facts and all of the exhibits here would cover all of the elements of counts 1 through 5, with the exception of count 2. We ask that you find the finding of not guilty by reason of insanity.
Ms. Tuttle, anything you would say?
Your Honor, we would also ask that based on the stipulation of fact and the exhibits presented to the court, you find Mr. Lehman not guilty by reason of insanity.
Now, I was gonna address Mr. Lehman, but I probably shouldn't do that, I guess, but it's a trial, he doesn't have to talk, he doesn't have to risk testifying. I guess I just wanna make sure you understand everything that's going on. Do you understand that? You're an attorney, I don't want you to divulge conversations, specifics that you had with your lawyer, but I assume she's explained everything to you that's going on, Mr. Lehman?
Yes, Your Honor.
Do you have any questions for me,
No, Your Honor.
in terms of procedurally what's happening? I'm sorry?
No, Your Honor.
You sure?
Yes.
You need any more time to talk with your lawyer before we continue on here?
No, Your Honor.
All right, well then, based on, the stipulation of facts that were provided to the court prior to coming on the bench, and that I just took the time to review, certainly the stipulation of facts, that will be filed and are signed by the, parties. And Mr. Lehman, you did sign this here, the stipulation of fact, that's your signature down there, if you can see it?
Yes, Your Honor.
Stipulation of facts certainly provide sufficient, more than sufficient evidence to cover all the elements of the offenses charged in the indictment. So in terms of there being enough evidence to establish each element of each of the 4 remaining charges, that's not a question. So if it wasn't for the NGI plea, the defendant would be found guilty of those 4 charges. However, the court also, based on the stipulation entered into between the parties to the both reports provided by the 2 experts here, and I did have the chance and previously to this day had reviewed and read both of those reports, and both reports opine that the defendant, due to severe mental disease or defect, did not know the wrongfulness of his conduct at the time of the commission of these offenses, which is the legal test here in the state of Ohio for insanity. Both tests opine that the defendant was in fact legally insane. I will adopt those reports as fact as well. So based on all the facts stipulated to between the parties, the court does find the defendant at this time not guilty by reason of insanity of count 1, robbery of felony in the 2nd degree, in violation of 2911.0282. Count 3, attempted grand theft of a motor vehicle, a felony in the 5th degree, in violation of 292302 and 2913.02A1. Count 4, aggravated arson, a felony in the 1st degree, in violation of 2909.02A1, as well as count 5, inducing panic, a felony in the 4th degree, violation of 2917.31A3. At this point, I will refer the defendant back to Dr. Runsberg for a report to determine civil commitment. We're going to have we'll schedule a civil commitment hearing. Does it have to be within a certain amount? Is it 30 days? Or is it shorter than
Maybe
that?
10.
Could be
I believe
10
it's
days.
10.
All right. Well, why don't you guys pop in chambers, we'll get a date then, and make sure that, and then we'll get a date since it has to be done quickly. And, we'll get this report to Dr. Runsberg, to prepare that report and go from there.
Thank you.
So Is there anything else we need to set forth on the record, Ms. Missouri, for the state of Ohio?
I don't believe so, Your Honor.
Ms. Tuttle?
No, thank you, Your Honor.
Yeah, if you don't mind stepping in chambers.
All right.
They're probably gonna take you back down, just wanna call me when you get back to jail, I'll tell you. And then I'm happy to talk with your family in the hallway.
We want to file a stipulation of fact, right?
Yeah.
Oh, I'll right here.
Thank you, Mary.
Hello.
Hi, Mary, how are you?
Good, how are you?
We're good. Correct. You guys have to stay right there. Thank you. I understand.
Okay, you guys can take, your attorney says call her when you're back in the jail, okay?
She want to let you know.
Say goodbye to your family.
Thanks, Dan.
All right, Danny, I'll call you guys shortly.
All right, sir.
Suddenly I had to shut my computer down when I shut the power off, so now I gotta reboot it.